Thank you so much for attending this month's TJR Scholarship Workshop, Unexceptional Protest, with Professor Amber Bailey, the Associate Clinical Professor of Law at Columbia Law. I am Kenitra Brown, Staff Attorney and Director of Engagement for the Deason Criminal Justice Reform Center. The Deason Center is a nonpartisan policy, research, and advocacy center housed at the SMU Dedman School of Law in Dallas, Texas. We use a stats and stories approach to smart, sane, and sensible criminal legal reform, with a focus on three major research areas: Sixth Amendment rights, with the right to counsel as the crux of our expertise, and an increasing focus on pretrial due process; STAR Justice, which is our small tribal and rural criminal justice series; and prosecutorial discretion, with a specific focus on screening and charging processes and district attorneys' offices. For our returning audience and those of you who may be new to Deason Center's TJR Workshop Series, these workshops provide a virtual forum for academics and researchers to share criminal justice works in progress and research with an audience of academics, practitioners, and other stakeholders. We're unique in the sense that we do these workshops with more than just academics, and so feedback can come from a variety of experiences in justice and for all people. This month's presenter, Professor Amber Baylor, is the founding director of the Criminal Law Clinic at Columbia Law, which focuses on defense representation and local criminal charges. Her work centers on local criminal regulation and its impacts on communities targeted by extensive policing. Her scholarships continues on this theme, including criminalized students, reparations and the limits of prospective reform, and design justice and municipal criminal regulation. Professor Baylor is a former staff attorney and public defender, and she's also written about the historic advocacy by women in prison, women in pretrial detention, and the impact of trauma from pretrial detention. Her scholarship has appeared in publications such as the Washington University Law Review, the New Mexico Law Review, and the Michigan Journal of Gender and Law, on topics that include pedagogy for representation of community-based organizations, enforcement and regulation of municipal low-level crimes in communities of color, and use of low-level criminal charges in student discipline. Before I pass the presentation on to Professor Baylor, please note that while we're recording the presentation, it will not be publicly available. You can feel free to ask any questions that you want in the chat, and we'll make sure to ask them out loud if you don't want to speak. But if you can show your face on camera, if you can ask your questions on camera, we would greatly appreciate it. I will help facilitate the questions and answers once Professor Baylor completes her presentation. Thank you so much. I will now pass it over to Professor Baylor. If you would give me a moment to start your presentation.
No problem. I have some things I can say before we get to the slides. Well, thank you all for being here. I so appreciate you taking the time to engage with this piece. And, you know, I think the emphasis or my project in expanding the scope of potential consequences when thinking about anti-protest legislation. Yeah, so I'm really glad to be here in front of this audience of people who are in practice, people who are thinking about these ideas as part of their research and scholarship. It's a unique space, and so I'm very grateful for the invitation to present here. So the project is titled Unexceptional Protest. It does center on anti-protest legislation. So, you know, the host of different laws that we saw, especially recently after protests following George Floyd's murder, that really curbed or heightened consequences for people engaged in protests. So it focuses on that set of legislation, but it taps into what I think might, you know, something I think might resonate for many practitioners, which is really what are the everyday consequences of both the proposed laws and then certainly for laws that bills that are passed and anti-protest legislation that becomes law, what are the everyday consequences? And I think, you know, protest tends to be centered, you know, as we think about these laws, the consequence to protest, the discretion, discriminatory uses of these laws depending on the protest and the protesters. But what I'm thinking about in this piece are these laws as simply expansions of order maintenance policing. So what does it mean to heighten the consequences for disorderly conduct, resisting arrest, for everyday policing and prosecutions? for people who are working in courts or have been in courts and through the system. We know that those are charges that people in targeted communities face every day for individual assertions of personhood, public expression, public gathering, joyful gatherings, things that really aren't encompassed in mass protests, but really are critical to the health of communities and to the health of individuals. And so my project is to expand, when we're talking about the risks of these laws, to really expand the scope of the conversation into everyday impacts. And so I've spent some time thinking about what it means to examine the everyday, and then how these laws have been made to seem as things other than order maintenance laws, but truly in operation are expansions of laws that are recognized as being discriminatory and causing significant impacts in communities that are intensively policed. So my project is, I'll start with sort of the origins of the project, and then talk a bit about what I mean by anti-protest legislation, give a description of some of the bills that have been crafted, and the language around the proposed legislation for folks who may not have been following it closely, talk about what the content of the bills are, and show, just as demonstration of my point that these are order maintenance crimes, and then shift to thinking about what it means, what is the everyday, what does it mean to have expansions of these laws that are crafted, are presented as narrowly targeted, what does it mean to really have them be at play in everyday policing and prosecutions, and then thinking about frameworks that really challenge and trouble the line between formal mass protest and everyday resistance and expression. And one of those frameworks that you all may have heard of recently is, or may have engaged in, is a joyful protest. And for me, it was a nice framework to use because it really does traverse from mass protest to individual expression, and really describes the sort of expression that can be penalized and repressed through order maintenance legislation. So that's my plan. I know we've reserved some time at the end for feedback, but if there are points that folks want to make in the interim, I'm happy to open it up and have a discussion as I talk through the piece. Any insights have been really, helpful for me in thinking about clarifying this argument or strengthening the argument. So I appreciate that. Okay, so let's start with slide 2. The next slide. Okay. So anti-protest legislation is, these are the central sort of bills that I'm examining in this project. I thought about whether or not it was useful to phrase them as anti-protest legislation. Back one slide. Yeah, I was thinking about whether or not it was useful to frame as anti-protest legislation, but I thought it was a descriptor that best fit and that was most commonly recognized. There are organizations that have collected proposed legislation across the country in the last decade or so, proposed legislation that impacts protests. And so these databases are in existence and accessible, and they're very useful for trying to examine, get a sense of trends, as well as the language used in the language that surrounds the proposed legislation. So for this project, I worked with a research assistant in examining anti-protest legislation from around the country. If you may go back 2 slides.
I promise I have no idea what just happened. Just hang on.
No problem. I'll keep going. We'll get our slides back. I worked with the research assistant in examining anti-protest legislation from 2015 to 2021. And we focused on legislation that emerged in the aftermath of racial justice protests. Although there has been anti-protest legislation that has been offered in response to actions and protests at pipelines, and then also some legislation that's emerged in the aftermath of white supremacist rallies and marches. We chose 2015 because we wanted to be attentive to legislation that emerged after Ferguson. And then that went until 2021. So we were also looking at legislation that emerged after Black liberation and racial justice protests following and uprisings following George Floyd's murder. In the years between 2020 and 21, so following the uprisings in 2020, over 80 bills were presented that curbed or heightened consequences for protests. And this was twice as many as any point in history. So we really are in the midst of, or we are in the midst of a wave of legislation that attempts to curb protests and has been especially, and has been offered in response to people who are out protesting police brutality and police brutality and everyone can see. Then I'll just run the slideshow. Okay, so I think I was in the midst of describing the laws that that we reviewed. So these were anti-protest legislation following 2015. We took a look at proposed legislation from different states around the country. Common charges that were addressed in the legislation were things like obstruction of pathway, obstruction of sidewalks, interference with police duties, riots, incitement to riots, trespass. So things that typically might be presented as lower level charges that were often that were addressed in this anti-protest legislation, right? So there was these are typically charges that were addressed in these bills. Some of the bills created and crafted new crimes. Others enhanced the level of or consequences attached to something like disorderly conduct. Some expanded liability, so incitement to riot, expanded potential consequences for any member of a group that was found to have created some damage. So expanding liability for group action. And some bills some bills attached enhanced collateral consequences to these charges. So for instance, limiting access to benefits, public education, or mandating no bail until first appearance. So there was some collateral issue that was there was some additional punishment outside of just the scope of the sentence for the crime that was attached to charges or convictions under these laws. So the goal of the project was to think about how legislators were promoting what were essentially order maintenance laws or expansion of order maintenance laws by exceptionalizing them as being very specific to either extreme protesters or extreme forms of protest. So, in many states, jurisdictions around the country, there's been critiques of order maintenance legislation. There may have been decriminalization. There's been bipartisan efforts in instances to decriminalize. But these anti-protest legislation seem to circumvent some of those same critiques by being presented as being extremely targeted. So in some instances, the legislation talked about the particular types of people who might be prosecuted under the expansion of laws. So folks who, in some instances, there was use of tropes involving outsiders traveling into the jurisdiction, or protesters that were engaged in anarchy. I offer as an example with a bill presented in Texas that talks about rioters, right? And so there was a particular form of protester that's described as the target of the laws. And other bills centered in on what was improper forms of protest. And so describing anarchist action, property destruction, chaos for the sake of chaos is one example of a descriptor used in this effort to really cast these laws as being very narrowly focused on the types of people that were destructive and were not engaged properly in protest, or the types of protests that the legislator viewed as illegitimate. And so some examples that exist in Oklahoma, there was a new crime created, making it a felony to commit non-destructive acts of expression. That phrase was not defined in the bill, but essentially creating a felony for certain forms of protest. In Arizona, disorderly assembly was enhanced to a felony. In Kentucky, disorderly conduct, the conduct that would constitute disorderly conduct, was expanded, and then some of the examples of collateral consequences from bills across the country are here. So the goal of the project is to expand critiques of protest legislation beyond just the protest event itself. So in the first part of the project, we took a look at the language of exceptionalization.
I think, is Amber freezing for everyone else?
Yes.
And
Hang on one moment. Amber, if you can hear us, you're Amber, hang on. Let's see if she can.
Thank you.
Yes.
I'm unpresent now.
I'm gonna see if I can share it, if it will let me share. Whew. All right, I can now share. So hopefully, all right. Amber, are you there?
Yes.
Okay, so if you can see the screen, it let me share finally. I'm on protest in everyday life. Do you want me to go up a slide? And maybe if I'm sharing, you can have more bandwidth for your internet connection.
Sounds good.
All right, I'm so sorry, everybody. All right, here we go. Amber, you're good to keep going if you want to.
Okay. Can you all hear me?
Yes, we can.
Okay, thank you so much for hanging on. Why don't I move quickly? That way I can make sure that I get everything in, hopefully before any other disruptions. Okay, so I was just describing our examination of the language of exceptionalism. So often the language surrounding legislation in debate, in media, and in the text of the bills themselves describe exceptional people, so outsiders, anarchists, fire starters, in its description of the targets of these types of laws, or described what the legislators viewed as illegitimate forms of protest. So one part of the project was to be able to draw out the tropes that legislators were relying on to circumvent critiques of order maintenance laws, in part to expose some of the hollowness of their arguments that these forms of laws are really exceptional and were distinct from expansions of order maintenance, policing, and prosecutions. The second part of the project was to think about whether or not there truly is this border between formal protests that the legislators were arguing were the targets of their laws, and the everyday experiences of people, individuals, and communities that are under intensive policing. And so one of the things that I wanted to do in the project was to trouble that boundary and to think about the ways that some of the elements in protests emerge in the everyday lives of people that live with under significant police surveillance. And so some of those arguments have to do with gatherings being viewed as dangerous, with individuals' inability to comply being read as refusal to comply. And these are elements that exist both in the context of mass protests, but also in the everyday experiences of people that are likely to be to face enhanced regulation under anti-protest legislation. I think I was using this idea of the everyday to expand beyond formal protest, but one of the things that I wanted to do in the project was also to explore other frameworks that engage in the everyday. And there was, I think, more material for me in exploring this idea in some social movement literature. And the literature talks about what it means to examine the everyday at large, so the everyday experiences of individuals and how they are impacted by state politics. And so it was helpful for me in that it gave me a framework to describe what it was. It created a framework for me to describe the problem that I was trying to pull out. This idea that everyday expression and resistance the impacts on everyday expression and resistance wasn't being contemplated in critiques of anti-protest law. And so here are some of the elements of an examination of the everyday that emerge in the social movement literature that I relied upon in the argument here. And I think the second one is really critical to my argument, that the big movements, the everyday is really, in contrast to big movements, the everyday is really what resistance, our expression, and daily or common practices look like. So in the piece, I offer an example of a community group that's out during literature distribution and cleanup. They have the Black Liberation flag flying, they're singing songs. I think in the pleadings, they say they're singing songs of Black love. And suddenly they notice that they're being tracked by police in an SUV and then subsequently stopped and eventually arrested and charged with things like obstruction of sidewalk, resisting arrest, disorderly conduct. And this example isn't one of a mass protest, but rather a community gathering, community form of expression. But they're charged with these laws that really are the laws that are at the center of anti-protest legislation. And part of providing this example as a demonstration of the everyday impact is to show not just that there are, that the regular, that the likely and regular prosecution of laws like disorderly conduct and resist are on people who are not engaged in mass protests, but also to show how really constructive health enhancing community activity can be targeted under these laws. In another presentation, a lawyer from LDF talked about a lawsuit they brought regarding policing during the uprising in 2020, but that they were specifically focused on an instance of how the policing during that time impacted people who were at, I think it was a community outing, maybe a cookout, unrelated to the protests, but they had still been targeted by the protest policing and charged, stopped and charged with these similar types of laws that are commonly used in protests. And so those are, there's, I think, plenty of examples of people who are charged with the laws at the heart of protests. But it's useful to think, I think, for me, it's useful to have examples of really sort of life-enhancing, joyful activity that is, that can be repressed and targeted under, targeted with enhanced consequences under these types of laws. So I think I would go to the next slide. Okay. So one of the frameworks that I found helpful in thinking about sort of health enhancing expression that traverses mass protests and everyday life was joyful protest. I admit I was in part drawn to joyful protest because, at the time I was doing this project, I wanted the motivation for the critique to be centered on something sort of celebratory, something beautiful, to be really expanding the critique to encompass the risk of anti-protest legislation on aspects of life that are great and joyful, rather than I suppose sort of being motivated by fear and more bad news for communities that are heavily policed. And so this idea of joyful protest, I thought, fit well into the argument because it's a form of expression that might occur at protests. So folks have used joyful protest as a construct to describe dancing at protests, various traditions that hold on to identities that have been targeted by the state, a celebratory, joyful affect that helps us envision what the world should be like. So all of those constructs and descriptors of joyful protest I found really compelling. And so there's examples of what that might look like in the mass protest, but there's also examples in literature and what that looks like in the day-to-day. And that also resonated for me, that these types of gatherings that are described, the community group and its literature distribution, the cookout that was targeted by the protest policing, that all of these things are life enhancing and necessary. And at times they may be unconsciously um, uh, uh, um, opposing order norms that are policed by the state. And sometimes it may not be conscious, but are instead just joyful gatherings and expression that should be protected. And so I use this as one example of a form of expression and gatherings that may occur in mass or may occur individually, but are equally likely to be targeted and potentially repressed by anti-protest legislation. So we can go to the next slide. So the goal of the projects is to describe and to really cast anti-protest legislation as expansions of order maintenance policing, to talk about the enhanced levels of discretion it offers police, to talk about the enhanced and heightened power it offers prosecutors who now have more potential charges at the ready, potentially charge stacking, potentially inducing pleas for people who are charged under new legislation, and to think about the ways that this expansion of order maintenance policing is not just dangerous for the protest, the formal protest and protester, but also for our daily lives, community gatherings, expression, assertions of personhood, and all of the, all of the ways that this will be significantly more damaging or impactful in communities that are already undergoing intensive policing, order maintenance policing. All right, so I think I made it maybe ungracefully through the argument. Hopefully everyone who stayed on followed, but I'd love questions, areas where you think clarification would be useful, counter arguments, all of those things would be really helpful for me in fleshing out the project.
Thank you everyone for bearing with us. This is the Q&A portion of the presentation. You can either ask questions based on your reading of the draft or on the presentation that or the presentation that Professor Baylor just gave. And if you want to ask a question, but again, you don't want to speak on camera, you can drop it in the chat and we'll ask it out loud. And I'll be watching for reactions if you want to raise your hand in case we can't see your face, but you wouldn't mind asking the question out loud. I'll take a moment before I take moderator or facilitator's privilege and ask a question to make sure there are no accepting, pretrial detention and accepting plea deals because you know the trauma of pretrial detention and things like that. But a lot of these anti-protest or the anti-protest legislation, a lot of these bills leave a lot of discretion to police, and a lot more discretion to police than, understand the criminal justice system, police, things come in from policing next to prosecutors. There's a lot of discretion here about policing and how they determine, what's unlawful assembly, what's disorderly, what's intimidating, what's supposed to be, what do they mean by intimidating to a police officer? Very, very minor crimes. And you mentioned that it could be used pretextually for other things. But again, there's a lot of discretion here. And then there's not a lot of description about when an officer lawfully can make that determination, just as a law officer. It doesn't have to be a law officer on duty, anything like that. So is that something that you're, that as you're making this argument, that's come up is the bigger, not just the discretion the increasing discretion for prosecutors, but there's also kind of like a lack of discretion or overbroad discretion for police who are actually the first points of contact with some of this. You're very rarely going to get a warrant for anti-protest legislation. It's going to be on site on the ground. Right. It's going to be on site on the ground. And that kind of discretion feels a lot scarier than, I mean, it's just as scary as overbroad prosecutorial discretion. But that part of it, and kind of overbroadness of what it's going to allow law officers to do. It feels like it can be a bigger part of the last critique of discretion.
Yeah, I think, there's been so much good work on order maintenance policing and the amounts of discretion that it allows officers that sometimes it's hard to gauge how much to go into it. But I mean, that's at the core of the argument. So I appreciate that comment in making, and that's a necessary thing to make clear. I think I've been influenced by like recent work on decriminalizing and eliminating certain crimes from the penal code, certain statutes from the penal code, in a sense, because I think that, I'm not a scholar of police reform. I don't know what types of trainings really eliminate that type of discretion, but I do know that there are laws that are, especially the order maintenance laws, that really rely on discretion, right? These are in some instances, they're so vague that it requires officers to decide when people are violating the law in ways that people may not be able to predict. In other ways, it really asks the officer to give, the officer has to be the person who is ascertaining danger, incitement, all of these sorts of things. And that's, under the language of the statute. And so I think my effort is more to curb the legislation
Generally,
generally, because it requires this sort of extensive amount of discretion that we know is used with bias and has discriminatory, sometimes intense, but often impacts. So yes, that's a critical component. I think there has been some work done on policing at protests and disparities in policing depending on who the protesters are. So we have in the piece some contrasts about public perceptions, for instance, they call it Black Lives Matter protests versus protests that are not centered on racial justice or don't have that label. And the policing differs at the protests and in Ferguson, protests in Charlotte. So there's been some work done on how policing is different during protests, and I think it's related to the argument about the impact of the laws outside of protests, but a lot of it's also been done in just examination of order maintenance, the regulation under order maintenance laws. Yeah.
So there's a question in the chat, and I think it's probably referring to, I think it's the Oklahoma statute that says non-destructive acts of expression at protests. What are the implications for constitutional rights when these types of laws are passed? And how has this law been used, if you know? And does it basically criminalize anyone who is at a protest?
It seems like it does. It seems like it might. No, so one of the things that has been challenging is, the piece centers on proposed legislation. So some of the laws passed, some of the laws have not, some are still pending. And I think, part of the project is to say it's the laws that are passed are important, but it's even the language that is used to oppose legislation is indicative of this effort to exceptionalize anti-protest legislation from regular order maintenance laws. This particular law, I don't know how it's been used so far. I haven't tracked how it's been used so far. I think this was out of Oklahoma, if I'm correct. Yeah, but the piece does cite to a database that of a nonprofit organization that is tracking legislation around the country, and typically that'll show what's been passed. Some of it is likely so recently passed that there may not be much. There may not be much data, as you know, on how they've been used. I think efforts to find instances of prosecutions, my efforts to find instances of prosecutions for some of the recently proposed legislation has come from civil liberties lawsuits that sometimes have that are able to, that sometimes address recently passed legislation and may have examples of improper uses of the laws. But yeah, I'm not sure what it's looked like so far in Oklahoma.
I'm going to take moderator privilege again unless I see someone's hands or someone speaks up. Okay, so I have two. So we talked about this one before, but to bring it up again, there I really like the argument where there's this question about these protest laws actually can have even among people who are advocating for less criminal regulation and who are looking for other ways of doing this, even for people who know how these laws can be used to increase surveillance of communities of color, that often they can go through because they seem reasonable. Because again, you have very public examples of what happens when protests aren't regulated, aka Charlottesville, aka the insurrection at the Capitol. And so suggestions to put in roadblocks and those types of things aren't as scrutinized at the legislative point where they're being offered, because again, we've had some very public examples of unregulated or not as heavily policed protest and the human destruction that it can cause. So I guess for people who haven't had a chance to read the paper and didn't get to kind of, it didn't get pushed in the presentation, I guess I kind of want to bump that up for your comments for people on the line so that they can know that that's an area that you spent some pretty interesting time on in the paper.
Yeah,
that's first, and then I have a second one. But go ahead.
Okay.
Yeah.
Let me have the first one. I'm so glad you're prepared with. As to that, for the first question, so I suppose the question comes from one of the counter arguments that I've been offered in this piece, which is there something different about legislation, proposed legislation that comes in the aftermath of January 6th or comes in the aftermath of Charlottesville that really isn't in response to racial justice protests or protests or uprisings following instances of police brutality, but come after what I and many people probably widely regard as maybe demonstrations that have repulsive origins and are really damaging, and that involve hate speech and all of these things. And so, for me as a former public defender, I feel like the answer was easy, but it was, I feel like I had an automatic answer, but I really, I think that maybe it was dissatisfying to a lot of people. So for me, expansion of criminal law is always going to be used with some discretion, and that discretion is almost always used to the disadvantage of marginalized or oppressed, traditionally oppressed and targeted communities. And so that is, was sort of my knee-jerk reaction. It was hard for me to envision a law that could be crafted to avoid that outcome. But for some folks, I think they felt that there was a significant distinction, and it was a distinction that had to be addressed. That I couldn't conflate the two. I couldn't conflate a protest for Black liberation and a protest supporting white supremacy. And so I do engage with some work that has been done that argues that First Amendment protections should not be extended to instances like the rally in Charlottesville, or other instances of hate speech and white supremacist messaging. And I try and draw a bit of a distinction between their arguments and what I'm focused on, which is really this expansion of order maintenance policing, and say that, you know, if they are not the exact same laws that are at the core of order maintenance policing, they are similar enough to operate in the same way, and that the criminal legal system cannot be relied upon to act in a manner that protects people of color or subjugated peoples more in these instances than in other instances where that just hasn't occurred. And so I try to push back against the expansion of criminal law, even where its target is white supremacist demonstrator. Does that address the question?
It does. It does. I just wanted people to hear the argument. I think it's, the argument is basically you don't have to expand it. There's already something for it.
I mean, the second half of the argument is the laws are there. So if the discretion, if prosecutors or police want to use their discretion to curb that type of protest, there are laws in place that can be called upon. Yeah.
And finally, this thought came up as you were talking about, we know the potential consequences for civil communities, for people who might be caught up in this. And I think the consequences are even more dire, because my question here is, these are laws that punish existence, or that feel like they punish existence, right? So like the question is, does it basically criminalize anyone at a protest? Or you're talking about the LDF defendants who weren't at a protest, but who were charged with protest-related offenses. And it's hard to prove a negative. Or we talked about this where Dallas police kettled people intentionally onto a bridge. And so those people were charged with, were initially charged with misdemeanors and felonies based on being present or obstructing traffic, that the Dallas police put them in. Do you know what I mean? So eventually public pressure got those charges dropped. But for smaller or other cases where you kind of just get wrapped up in these laws, or in the enforcement of these laws, just for existing, I wonder about how that, about defending it. We know the consequences for the people in it, and it means it also increases surveillance. But as a former public defender, there are public defenders on the call, former public defenders or academics. Have we thought about, the difficulties in actually defending these types of charges? Does that make sense? If you're being punished for existing, there is, right, if your punishment is a group of 3 of you, which is what some of these laws encompasses, if you just got to be 3 of you who are allowed, but we got you on this protesting. How do you defend that? Because it's basically an ordered crime. Like we mentioned this, but it's in particular with these types of crimes, even though some have passed, some haven't. I wonder if in that LDF conversation there was a discussion about how difficult it might be, or or transversing that kind of conversation with those types of clients.
Yeah, so I think one of the one of the benefits of expanding the critique of these types of laws to the everyday, to the non-protester is, I think within people's mind, there's some sort of volition, like voluntary act of engagement in protest that comes with its own risk, which is not to validate the use of these charges against protesters, but rather to say that there are everyday conditions that can sometimes mirror these aspects of protest. So, I love the example that you gave of people being heckled on the bridge during protests in Dallas, and how that created a condition where people could not comply, people could not disperse, but then they were subsequently charged with failure to comply. But the project looks at what the analogy to that might be in the everyday. And as you had mentioned, can sometimes appear to be punishing existence. I think for me, one of the things that was really potent about thinking about the everyday uses of anti-protest law and order maintenance was thinking about, yes, the young people that many of us represented who have been charged with disorderly conduct or obstruction to public duties because they've asked a police officer why they're stopping their friends. So thinking about the everyday impacts on people who are charged under these laws, but also thinking about the impact, what impact it has on many of us who will self-regulate, right, in order to avoid potential interaction with some of these, with policing under these laws. And so I think the impact can be sort of very deep. It can be very obvious in some ways, but also very deep and strike at the core of things that are really at the center of our humanity, is public expression, public gathering, and all of those sorts of things. And thinking about defending, I think one of the things that was said in a prior conversation about this piece is that most of these laws won't be tested in the instances of their everyday sort of uses, right? In low-level prosecutions, most people are not going to trial. In some places, things like disorderly conduct are charged in courts where people aren't guaranteed counsel. And in some instances, like in Dallas and other places, you might have brought this up, charges are eventually dropped, right? So there are, an array of instances where the laws are never tested, but the consequences are already felt. They're felt by individuals who are stopped and arrested under the laws, and they're felt by those of us who feel potentially vulnerable to the type of order maintenance regulation that's happening under the laws as well.
Anybody else? Comments?
I would love
questions?
anything. Yeah, clarifications. I mean, any responses? Does it resonate? Does it not resonate? Differences in your experiences, all of those things would be really helpful. Yeah.
I see a hand from Peter Stephenson. Do you want to ask out loud, or do you want to drop it in the chat?
Yeah, I can ask out loud. Hi, Professor Baylor. Thank you so much. I think this is really important and interesting work. So thank you for all the hard work that you've clearly poured into this draft and for this conversation today. I'm a law fellow here at the law school in the First Amendment Clinic. But one of the things that this had me thinking about as well in reading through your draft was the role that sort of this new wave of civil and regulatory enforcement provisions play in your framing, and in particular, what this got me thinking about was the role that community bail funds in particular have played as a community response and reaction to the over-criminalization of and overuse of anti-protest laws, and especially, as you point out, how the use of these laws has crossed over into or beyond the realm of the protest space into the ordinary, everyday, kind of mundane criminal enforcement in communities everywhere. And what we saw during the last legislative session in Texas is that, and I know in other states, was that there were laws that were passed that targeted community bail funds specifically to ensure that, particularly where those funds organized or formed around responding to mass arrests at protests, then those laws, imposed significant regulatory burdens to ensure that these funds were able to do their jobs less or just weren't able to operate entirely. And so I'm really interested in your thoughts on sort of like the future of those laws and how they fit into your thinking today, particularly about the overcriminalization of protests in general.
Yeah, thank you for bringing that up. I hadn't, I followed what was happening in Texas and the backlash against community bail funds, but I hadn't thought about it in the context of this piece. And I do wonder, I know that the community bail funds are particularly active at the moment of uprising and protest, and I don't know how, and in that way they offer, they offer, mutual support as a form of dissent. I hadn't thought about what that might look like. I don't know much, I would say, about what that looks like in everyday or maintenance policing outside of, general bail funds that exist that aren't targeting or that don't target, that aren't thinking about people after a particular event. And so I just hadn't connected that to the piece. But I think I have to think about how that connects a bit more. But thank you for bringing it up. I need to think about how it connects a bit more.
Sorry guys, I thought I saw a hand the first time around. Was I right or was I wrong? Or was something covered? Can't see who KM is, but they really appreciate this research and it's resonating with them. So I'm sure Professor Baylor appreciates that comment.
Yeah, KM has been really supportive. So thank you, KM, for your thoughts. Appreciate it. Yeah, and thank you, Peter, as well, for the comments on bail funds. I have a question. I guess one of my questions might be back to Peter. Do you know of, when you're thinking about connections to the, like, how these laws apply to people outside of mass protest, is there a particular thought you have about the role of community bail funds? Oh, thank you, Kim. I appreciate it.
Yeah, so in a past life, I worked for a civil rights organization that did a lot of policy and organizing work around the bail funds who are here in Texas. And I think like one of the common things was that, certainly bail funds would receive an influx of funding around protest moments because of how many arrests resulted in those particular instances. But, when I guess it's maybe not necessarily fair to say that when the dust settles, but like, as they became more professionalized and more developed and are able to create this rotating funds that they can continually use for things that are outside the protest space, what they end up focusing then on are the needs of their communities where they're organized, and that tends then to focus on like, of course, misdemeanor. I think, it's exactly like you're saying, sort of order maintenance crimes in the communities that they're particularly seeing. And so many of the bail funds that I used to work with, that I was connected with, they were organized around a church. They were organized around a neighborhood. They were organized around individuals and in responses to groups and moments, but eventually settled into sort of the day-to-day, reacting to community needs, and developing policies and processes to ensure that they were a consistent mechanism and honestly released valve for the people that they served. And so it's one of those instances that got me thinking when I was reading the article that there's, I think, a very clear trajectory from these funds developing in the protest space or in response to sort of protest movements and in response to sort of protest laws that then transitioned into a much more substantial form of community response and pushback to not just protest laws, but policing in general.
Okay. That's awesome. Okay, thank you. That's really helpful. Yeah, thank you, Peter.
Thank you. And like I said, I really enjoyed your article. So thank you again for all of the work and thought that you put into it.
No, yeah, no, I appreciate you being here. And I feel like I haven't figured out where this fits, but I think it is a really important aspect to consider and think, especially in thinking about things that traverse and move from the moment of the mass protest into the everyday. So I really appreciate the thought. I have to figure out how I might fit it in. I think Kim.
Hello, I'll stop typing. I was just curious, when you talk about the new legislation, and you mentioned that sometimes laws are passed, sometimes laws are not passed, even though they're proposed. Do you look at any of the reasons for why laws don't pass? What's stopping different jurisdictions from creating these laws, even though that they propose them?
I mean, I think in some places the things that are troubling so many of us may be troubling enough to enough representatives that the laws don't pass. They're vague, that they're overly punitive, that they criminalize what is more broadly considered lawful forms of expression. So I think in some instances those are the reasons. I think one of the things that perhaps I need to flesh out as a part of the piece is why the language that surrounds even the bills that don't pass, the ones that are floundering, the ones that don't make it through, or the ones that are still pending, why countering that language and that exceptionalization is still important. In part, it's because there were so many that were proposed in this moment that it seems to symbolize just a trend and an effort to distinguish who is the target of the laws and what it's targeting from other common everyday misdemeanors that are applied on the street. Yeah, so I think the project hasn't necessarily tracked how well the laws have done in the state legislatures, but rather been more focused on the language surrounding it in debate and media and in the bills themselves.
Thank you.
So probably, not the answer you're looking for, but where I've focused so far in the project. Do other folks have things that come to mind or areas that they think need to be clarified or further explored in the piece? I think that would be really helpful.
Hi, sorry, can you hear me?
Yes.
Oh, hi. Hi, my name is Jia Chen. I am an attorney at the Deason Center, and I was just curious if you could talk a little bit about these anti-protest policies in like larger context of criminal public order laws? Because I think I remember reading in a segment of your paper, you talked about there's kind of a, let me see, I think like a well-established skepticism towards public order crimes. I'm just like, I would just love to hear a little bit more about it. Like when you see where these have like is does the kind of the trend track in states that it got passed or didn't pass, how it relates to how progressive or conservative the state is. Just generally, I'm just really curious because of that sentence that you wrote. I was just curious to if you can talk a little bit more about it.
Yeah, thank you for asking about it. And so I think the piece pulls on scholarship on order maintenance criminal laws. And so, you know, I think of our work like Jamelia Morgan's work on disorderly conduct, or Dorothy Roberts' work on order maintenance, policing. And in those pieces and in that sort of trajectory of work, there's a discussion of how criminal law is, you know, is a tool of social control, but also how it controls towards order as defined by the dominant sector of society, and that those norms sort of control how discretion is used in policing things like disorderly conduct, or resist to arrest, or things that are common in these types of charges, obstruction of a public walkway, that they prioritize certain forms of order, which is, you know, a walkway is open in front of a private institution. They're open in front of private businesses, and can cast certain people as disorderly, right? And so that necessarily means that there's some disparities and discrimination in how those laws are applied as well. And so I think one of the things that is, you know, a pretty easy takeaway in looking at the anti-protest legislation is that most of it, you know, some of it involves new laws, but a lot of it is expansion of laws that already exist. But the protest moment provides an opportunity to enhance the consequences. And so disorderly conduct is regulated every day, but now it's a felony if, you know, X thing occurs, or it occurs in X place. And so it really sort of it draws on what we already know about order maintenance laws and policing, and demonstrates that now the consequences are even more dire. And in some instances, the discretion for officers to determine when one is in violation of the norms as defined by the dominant sector of legislators, that discretion is widened even further by some of the changes to the language of the statutes because of anti-protest legislation. Yeah.
Thank you.
Yeah.
Well, thank you everyone for joining us today. And we're just a couple of minutes over, but I am so thankful for those of you who had comments or thoughts. If you would like to share your comments directly with Professor Baylor, she dropped her email in the chat. It's abaylor, ABAYLOR @law.columbia.edu. If you want to share any thoughts on her paper directly with her or her presentation. So thank you all so much. I appreciate you being here. I also dropped a link in the chat for our STAR event, our small tribal and rural criminal justice event next week, which will feature a panel of practitioners and experts in post-pandemic realities and reforms in jails in a post-pandemic, but still epidemic world, what reforms look like for jails, pretrial detention, and small tribal and rural areas. So if you're interested in attending, please check our upcoming events link on our website at deasoncenter.smu.edu, or check the link in the chat. And please bookmark our calendar. I will be uploading our fall calendar soon so that you all can be aware of upcoming events, particularly in this TJR workshop series. We have some very exciting upcoming workshops starting in September. So I look forward to seeing you all at future events, and have a great rest of your day.